5 seconds to go. Start. Shri P.N. Saxena, Learned Counsel for the Appellants, contends that the procedure adopted by the two professors in declaring the result on a manual check of the OMR sheets is in contravention of the mode prescribed, which should have been done by the computer center through a scanner. He submits that there was no occasion for the two in charge professors to have undertaken the evaluation themselves manually. He further submits not only this, the manner in which there has been a substantial change in marks of one of the students and few minor changes in the case of 6 other students raises a serious suspicion and a genuine doubt about the conduct of the two professors who undertook the exercise of change of answer sheets manually. He further submits that there was no provision for any such rechecking or scrutiny, and the declaration of the list on 1st April 2010 was unsupported by any authority. It has further contended that the learned single judge committed an error by accepting the submissions made by the respondents, which was directly in conflict with the relief claimed by them. He submits that the respondents had clearly questioned the correctness of the subsequent list and had prayed for admissions being made on the basis of the first list published on 19th February 2010. Accordingly, it is submitted that the learned single judge ought not to have granted the relief as prayed for. Sri Saxena has further invited our attention to the application moved in this special appeal, making a prayer that an appropriate direction be issued to the university to ensure transparency in holding of the examinations and the declaration of the results, as well as evaluation of the OMR sheets, so that in case any student has any doubt, the same can be ascertained by adopting a fair procedure. Shri V.K. Singh, learned senior counsel for the university, contends that the university may not have filed an appeal against the impugned order, yet the university supports the cause of the appellants and at the same time would abide by the orders of this court. He, however, takes exception to the finding and observations that were made by the learned single judge on the steps taken by the Vice Chancellor, and he submits that the Vice Chancellor, in order to ensure fairness, had taken a decision to cancel the examinations on the asking of the candidates themselves. He further submits that prompt decision by the Vice Chancellor was taken as he was wholly unaware about the two in charge professors having manually evaluated the results, who upturned the same through a revised list. He further informs the court that the Vice Chancellor was not made aware of any such action being taken by the two professors, and they did it on their own without any authority. Accordingly, the Vice Chancellor immediately constituted an inquiry committee, and after having received the findings of the said committee, cancelled the examination in order to ensure fair admission in the postgraduate courses. Stop.